So the International Court of Justice is in the news because, as mentioned, because of this genocide case brought by South Africa. So I'm going to talk a little bit about the case, but then I actually want to put it into the broader context of these types of legal efforts, which actually I coined a term in the conflict, lawfare in the Arab-Israeli conflict. I didn't coin the term lawfare. Academic in America did that, but I coined it for a lot of these processes that are going on at the UN and by NGOs, and how these mechanisms, these human rights and judicial mechanisms, are being exploited for anti-Israel advocacy. And so, while I'm going to focus on the ICJ case, I want to talk about some of these other things to also help you put it into the broader political context, and it'll help explain what's going on. And also, I should note that you are all welcome to go to our website, which is www.ngo-monitor.org, where we have so many reports, information on NGOs, information on funders, information on a lot of these campaigns. So there's tons of information there that you can look up if you want to go into further detail about some of the things I'm speaking about. And in terms of the UN, we do have accreditation at the UN. So I frequently participate in and appear before UN bodies, notably the Human Rights Council. So a lot of what I'm going to be speaking about is based on my own personal experience as well, and things that I've seen from the inside. So it's something that a lot of people don't get that opportunity to see really what's going on the ground there. So let's turn to the International Court of Justice case. So this case was brought about a month ago by South Africa, and it was brought at what is known as the International Court of Justice. Now, it's important to note the International Court of Justice is the UN court. It was established by the UN Charter when the UN was established. And the purpose of the court, it really has two functions. Number one is to settle disputes between countries. And it's important to note that the jurisdiction of the court, whether or not the court can hear a case, the states have to agree to be members of the court. So if they don't submit themselves to the court can't rule on a case against them. So that's an important point. And the other function that the court has is what's known as its advisory function, where UN bodies can submit a question to the court where they're debating over a question of law or some other type of question, and they want to get advice from the court. So that's its other function, its advisory opinion function. And those you don't need state consent because that's sort of an internal agency advising function. So like the UN General Assembly might have a question it wants the court to answer. Now, advisory opinions, and the reason I'm getting into that is because it will become relevant shortly. The advisory opinion function is not binding. It's basically their advice. So that's important. When you're dealing with a dispute between countries, technically the ruling is binding, but it's not enforceable. So there's no way to enforce a ruling that the court makes. And there are many cases where a country will not uphold the ruling of the court. So that's also just something to keep in mind. And really, that's something when we're dealing with international law, I think just in general, because the court rules on issues of international law. International law is tricky because it's very amorphous. So it's very hard to often define what international law says in many instances. It's not like in the United States, for instance, where we have a very established court system. You're probably all familiar. We have a state court system and a federal court system. And within both of those systems, there are many layers. You have a lower level courts, district courts, appellate courts, Supreme Courts. And you have checks and balances. So even let's say the Supreme Court makes a ruling, Congress can then pass legislation. If they don't like the Supreme Court's ruling, or depending on what the Supreme Court says, Congress can pass legislation. And you also have then, then the Supreme Court, also there's a check on that legislation. Does it meet with the US Constitution? So there's many layers to these courts and holding them accountable. And there are also many rules. There's very well established rules of procedure, how the courts function, very established rules of evidence, how a court comes to its determinations. Those are very important. It's very transparent. And then there's also a system in the US legal system about precedents. So you have to follow what the courts going before you have said. It's the courts try not to make new law. They don't favor making new law if they don't have to. So that really distinguishes a domestic court system from the ICJ, or a court that's dealing with international law. In contrast, international law is very amorphous. There are treaties that countries sign up to, but and those treaties lay out rules that if a country has agreed to join a treaty, that it basically is saying, okay, we agree to be bound by the rules of this treaty. But many times the way in which the treaty is written is not very clear. There are not clear precedents established. The rules of the international courts, including the ICJ, are also not very detailed. And sometimes they really make it up as they go along. So it's not like a domestic court. Also, many of the judges, when you're dealing with international courts, they're political appointments. So in the case of the International Court of Justice, the judges are picked by the UN General Assembly and the Security Council. So these are political appointments. Many times the people are not judges by profession. Many of them may not even have legal experience, international legal experience. A lot of them are academics. A lot of them are politicians. A lot of them may be opining on things related to military operations. Very few, if any, have any military experience. Um, and they have very little, let's say, connection to reality of how things are working in places. And there's no accountability. So if there's a bad decision made, there's really no address to go to. So that's again something that sets a court like the ICJ, these international courts, apart from domestic court systems. So this isn't just a problem with the ICJ, it's a big problem at the International Criminal Court and many of these international courts. So these are all things we have to keep in mind. Also, when we're dealing with the International Court of Justice, we of course have to remember that this is a UN court. So because of that, the ICJ is going to rely on UN information. They will probably privilege that information, and a lot of the dynamics that play out at the UN end up influencing the ICJ. So when we deal with a case involving Israel, and I can get into that, a lot of the discrimination against Israel at the UN, that carries over into the ICJ process. Now, it's a little bit insulated from what you might see at the UN General Assembly or some of these other bodies at the UN, but it is a UN court. So, for instance, and again, I'll get into more details, but they will cite to UN reports that, let's say, rely on Hamas, and they will take that as a given. They won't challenge the credibility. So that's something to keep in mind. And also, they don't have a lot of resources. They don't have fact-finding resources. So again, when you're dealing with a domestic court, courts have what's known as a subpoena power. So if they want to hear from a witness, or take evidence, they can force people to testify. They can force evidence to be produced. There's a very robust, especially in the United States or in England, there's a very robust process of being able to challenge the other side and their evidence. And again, that does not exist in an international court. So one side is allowed to make many claims, and there's really no process that ensures that that information is being verified or tested, and the other side doesn't really have much opportunity to challenge what the other side is saying. So again, this is something that is going to come up in our case. So basically, so why did this case happen with South Africa? So South Africa, I'm sure, would have loved to have brought Israel to a case at the ICJ, but they can't just bring a case. So Israel does not, I think, in most cases, recognize the jurisdiction of the ICJ. And also what types of disputes the ICJ can hear are limited. So what South Africa did was there's a treaty called the Genocide Convention. Convention is another word for a treaty. And under the Genocide Convention, one of the provisions of the convention says that if there's a dispute between two parties, they can bring their dispute to the International Court of Justice. And that is that is the mechanism that South Africa used to try to bring this case against Israel. And because Israel is a party to the Genocide Convention, South Africa was able to do that. Now, in the past few years, this process hadn't really been used before, but it was used a few years ago by the Gambia, brought a case against Myanmar for genocide. They claimed they were committing genocide against the Rohingya minority in Myanmar. So that was the first time it was used. And then there was another case between Russia and Ukraine, which was a little bit backwards. Basically, Russia, when it invaded Ukraine in 2022, in end of February 2022, they said their excuse for doing the invasion was to prevent genocide. And so Ukraine brought a case against Russia at the court saying, basically, for a finding that Ukraine was not committing genocide. So it had been used in recent years, and so South Africa decided they wanted to also use this against Israel. Now, the other thing that they did was, instead of just bringing a case, which would take a long time, the cases at the ICJ take a long time, it can take many years. So, but really the reason South Africa did this was for the PR value, so that they could get a PR win against Israel. And they have won in that respect, because everyone has been talking about this case. And now there's an association with the phrase genocide with Israel over what's going on with Gaza. And the other thing that this accomplishes is it diverts attention from the actual genocidal acts that occurred by Hamas against Israelis on October 7th. So that's why South Africa did it. It was two purposes. A, to have bad press, bad propaganda and bad press against Israel, and also to divert again attention away from the atrocities of October 7th. That was the political aim of South Africa in bringing this case. So the way they did that, not just filing the case, but to really make it a big story in the news, they filed for something what is known as provisional measures. And that, you may be too young to really understand, but in domestic courts, there's something called like an injunction. And you can request, so an injunction basically means they want the court to make some early rulings that won't prejudice a case later on down the road. So, like, for instance, let's say you were being accused, let's say one company was being accused of stealing another company's technology. So they might rule for an injunction from the court to basically tell the company that is alleged to have stolen the technology, you're not allowed to use the technology until we figure this out, because if they continue to use the technology, the other side could end up suffering even more harm. So it's a way to kind of preserve the status quo until the court can really hear the case. So South Africa used this procedure at the ICJ, and they basically asked the court, like, while the case is pending, to make some preliminary decisions that will not prejudice our case later on down the road, let's say. So they basically asked for things like Israel must comply with its obligations under the Genocide Convention. Israel must preserve evidence if there are evidence of things that might point to commission of genocide. Israel must provide humanitarian aid to prevent genocide. But the big thing South Africa was asking for was a ceasefire. So they wanted the court to order Israel to stop its military operations. Now, 2 weeks ago, so this would have been January 11th and 12th, the court held a hearing on these measures. Was it going to agree to implement the measures that South Africa requested? So on the 11th of January, South Africa gave a 3-hour presentation. And then on the 12th, Israel gave its presentation. And again, in these presentations, there was no way to challenge what the other side was saying. Luckily, Israel went second, so it was able to respond to things that South Africa had said the day before. But you couldn't at the time, if South Africa said something that was wildly incorrect, Israel couldn't say right then and there, wait, what are you saying? That's bogus. That's not true. So it complicates things that you don't have that mechanism to challenge. Now, also in South Africa's complaint to the court, it was basically an 84-page brief to the court, and the presentation followed the brief. Now, what this brief did was it basically claimed Israel is committing genocide in Gaza, and they alleged two things as the proof of this. They gave several examples. Number one was what they claimed was denial of humanitarian aid. And therefore that was the way they were going to commit genocide. The fact that Israel had moved, not itself, but had ordered part of the population in northern Gaza to move to southern Gaza during the fighting. They said that was also an example of genocide. And the other thing that they said was they had some quotes from several Israeli officials that they claimed was indicative of genocidal intent. Now, what is genocide? So in the treaty, what you have to look at is it's whether or not you are engaging in acts such as killing or other bad acts meant to destroy a national, religious, or ethnic group. I'm not quoting it exactly, but this is the gist of it, in whole or in part. But the key point of the Genocide Convention is you have to show intent. The party has to intend to want to destroy the group. So, and let's look back to World War II, which is when the Genocide Convention grew out of what the Nazis did to the Jews. So the Nazis were very clear. Their aim in setting up all these concentration camps and deporting the Jewish people was to destroy Jews, to eliminate Jews from the world. That was the intent of the Germans. They stated it and they carried it out with the gas chambers and all the things we know about the Holocaust. So you can't just have genocide, let's say, without that intent. Why is that? Because, of course, that would mean anytime you fight a war where you have killing, or these other bad things happening, that would mean you're committing genocide, which is not the case. The crime of genocide is a very specific crime. It's not fighting war. There are other crimes that could take place when you're fighting a war. There are war crimes, crimes against humanity. There are other types of crimes that could happen from fighting a war. You could have genocide in a war context, but genocide is very specific. It's not simply the fact that there's a war being fought and a lot of people have died. That's not what genocide is, but that's what South Africa was trying to do. South Africa is trying, in its case, to basically rewrite the definition of genocide. And so I think that also is a very dangerous thing it is trying to do because it's completely diluting the meaning of the crime of genocide. So also what they did in their case, in terms of diluting the crime of diluting what genocide means, is they made a lot of first of all, they erased the context of October 7th. They barely mentioned it in the complaint. They mentioned the atrocities in a very minimal way. They pretty much erased the horrors of October 7th. They eliminated that context of October 7th from the complaint. Hamas is barely mentioned in the complaint. They don't mention what Hamas has been doing in Gaza. So they again erase the context of Hamas in Gaza. They don't mention that Hamas for years has been building up terrorist infrastructure, that they've been embedding in hospitals, and they've built these tunnels, and they're keeping hostages in the tunnels, and they've been putting weapons in schools and doing all of these things that make it very hard for Israel to fight its battles. Also, in terms of humanitarian aid, South Africa did not mention all of the steps that Israel has done to try to protect civilians. So they claimed Israel was forcibly removing the civilians from northern Gaza, but what Israel was doing was trying to protect the civilians, which is required to do under the laws of war. It was trying to separate out the civilians so that they would not get hurt. It drops leaflets, it sends SMS messages, it makes phone calls. It takes all of these steps that, again, are not really actually required. They go above and beyond what is required under the law to protect civilians. They didn't mention how Israel was allowing in all of this humanitarian aid, even though it is not required to do so under international law, that it's inspecting all of these trucks for aid to go in. At one point, South Africa attacked Israel for not allowing aid to go in through one of the crossings into Gaza without mentioning that Hamas was the one who destroyed the crossing. So there were a whole host of these types of false statements or misstatements in South Africa's brief. And then also, in terms of the quotes of these Israeli officials, many of them were taken out of context or not fully or misinterpreted. And also, many of the quotes were cherry picked and were made by people who have no role over what's going on in Gaza. So every country has crazy people in government, as we know also in the United States. And so, but those people have no control over military policy. So, although those statements maybe are regrettable or offensive, it doesn't mean it's genocide. So that those were some of the most egregious things that South Africa did. Now, what happened on Friday? So basically, you have this hearing the 11th and the 12th. And then the court took it under advisement. And basically, what they ruled on Friday was they were, and also I don't want to get into it too much, but basically Israel was arguing that there were the court didn't have jurisdiction because South Africa hadn't complied with the rules under the treaty. But that's more of a technical point. So the court basically said on Friday that the case could go forward. So whenever that happens, it could be years from now when they actually get to the merits of the complaint of genocide, is genocide taking place. The court said that case can go forward. But what it ordered in the interim measures is it did not order that Israel had to stop fighting. It basically said that Israel had to comply with its obligations under the Genocide Convention, which it's already doing. And it basically has to report back to the court in a month over what it's doing. And it has to prevent incitement, meaning, if people are making bad statements, they should be punished. But they did not grant South Africa's main desire for bringing this case was they wanted the court to order Israel to have to stop fighting. Now, it could have been very possible the court would have done that because it is a UN court, and the numbers on the court, the way the judges break down, it was not favorable to Israel. So it was actually a big win for Israel that they did not order the ceasefire. It would have been absolutely ridiculous for a court to order Israel to stop fighting and basically give Hamas a win in the war. That would have been absurd. But also, you're allowed to fight wars. We don't like wars. Wars are very horrible. It's been awful for us in Israel, but Israel did not start the war, and we have hostages there. And we're fighting this war now to get rid of Hamas, who keep saying they want to do October 7th over and over again. So it would have been just patently ridiculous if the court had gone along with that. So thank goodness they didn't. And they also called for the unconditional release of the hostages, which South Africa was trying to avoid in its submissions. So on the one hand, that was very positive. But on the other hand, the case is still going forward, which is ridiculous and is basically an exploitation of the Genocide Convention. And again, as I'm saying, it's these two reasons. It's for this propaganda effect and also to divert from October 7th. So it's patently ridiculous. So it's kind of a mixed bag that this case is going forward. Now, there was a very strong dissent in the case from a Ugandan judge, and she basically said this was ridiculous. It's the Israeli-Palestinian conflict is a political dispute, and this is an exploitation of the court to try to impose a political solution that the parties have to negotiate and figure out for themselves. There was also a dissent from Judge Aaron Barak, the Israeli judge, who Israel was allowed to appoint to the panel. South Africa and Israel were both able to appoint judges to the panel because under the rules, if a country doesn't have a national on the court, they can appoint somebody. So both South Africa and Israel were able to appoint judges. So Judge Aaron Barak, who was the former president of the Israeli Supreme Court, very famous jurist internationally, he also wrote a very strong dissent about what the court was doing. So that's where we are. But again, and I'll stop because I see I've been talking a while to take questions. But really, the main takeaway though, what I really want to impress upon you all is this is part of a bigger political campaign. Again, of anti-Israel activists exploiting these judicial mechanisms to try to impose their preferred solution, either in this case a ceasefire, which would aid the Hamas agenda, or these other mechanisms which are aimed at demonizing and delegitimizing Israel as the nation state of the Jewish people. So that's why these cases are being brought. It's an abuse of these mechanisms. But unfortunately, again, because the UN is, even if you had, let's say, all of the Western countries or allies of Israel siding with Israel, you automatically have a majority at the UN that is going to be anti-Israel. So Israel can never really win a vote at the UN. And that compounds the problems in these mechanisms. Also, I'll just say one last thing. Because they rely on UN reports, it's also highly problematic because these UN reports are also generally made up of information from anti-Israel NGOs. And I have that's a whole other talk I could give. But again, every step of the way in the system, you have this bias built in, which is almost always going to give a negative result to Israel. And I just want to say there are many things actually pending against Israel at the UN right now. There is another ICJ case impacting Israel that's going to be happening in mid-February, February 19th, because a year ago, the UN General Assembly asked the ICJ for an advisory opinion about what they claim to be Israel's discriminatory practices and illegal occupation. So they basically want, again, very similarly, the ICJ to issue a ruling that everything Israel is doing is not because of terrorism, but because they are motivated by racism and they want to dominate Palestinians. So that's something that's going to be coming up in a month. But it's again very similar to the genocide convention, but this was very egregious and very painful for us as Jews because, of course, because of our history in the Holocaust. So, and also what happened on October 7th. So to accuse actual victims of genocide, of perpetrating genocide, is again very egregious. And it's a way to kind of one up what happened, because in the narrative that's frequently portrayed against Israel, Palestinians are portrayed as these innocent, agentless victims, while Israel is the evil oppressor. And what happened on October 7th disrupted that narrative because of what happened to us on October 7th. And so because of that, the Palestinian activists, the BDS activists, had to come up with a way to one up the atrocities that happened to us. And really the only way to do that would be to accuse us of the worst thing that we could be accused of, which is genocide. So again, this is just putting it into the political perspective. So I'll stop there. I know I've gone on a little bit long, and I'm happy to take your questions.
All right, thank you so much, Anne. Hopefully you can see me. For those who don't know, I'm Dan Brooks. I'm a Club Z educator and National Activism Officer. I'll be leading the Q&A, be taking over from Jake. So we already have a couple of really good questions. So I will ask, what will it take for this case to get completely dismissed, if that is possible?
Yeah, so I do want to stress that the court did not make any findings at this stage. I think that's something that's being kind of misrepresented. They did not make any findings that genocide was being committed, as ridiculous it is to even say that. This was a preliminary, in a way, it's kind of technical. They were saying that if we're going to accept everything that South Africa says as true, there could be a dispute about genocide, so we will allow the case to continue, but we're not making any findings on anything. We're only allowing the case to continue. So that's really what's going on. Oh, can you repeat the question? I got sidetracked a little bit.
Sure, it was just what
Yeah.
will it take to get the case completely dismissed, if that's possible?
Sorry. Okay. So it could be when they get to the merits of the case later on, which could be many months or even years. They will go again over the jurisdictional question. So that could be where the case gets dismissed. Because the court may say, when they've actually had a chance to review the evidence, they may say there isn't jurisdiction. Probably unlikely. I mean, I think they have a very hard. The problem is, if this was a domestic court, this wouldn't even be an issue. But because we're dealing with the UN court, it's very up in the air. So it's probably going to be hard to get the case dismissed, even though I think the claim is ridiculous.
And here's a question I haven't really heard, which is very relevant because obviously, as you pointed out, and as we all know, Hamas is attempting to commit genocide, and they have. So, can Israel accuse Hamas of genocide in the same court? And what
So
is the
yeah, so it's tricky. They can't because Hamas is not a state.
right?
Now, they could certainly they can talk about it, which they've been doing. Israel can do that in the proceedings. What they could do though is they could bring a case against South Africa or I'm not sure about Qatar because I don't know if Qatar is a party to the Genocide Convention, but they could against Iran. And they could say, these countries are funding, supporting, promoting Hamas genocide. So I do think it would be worthwhile for Israel to go against these countries and go after them.
Yeah. Another question is, and you alluded to this earlier about enforcement, and really is what is the level of enforcement of ICJ rulings or measures? Is there any measure of enforcement that's even possible in terms of mechanism?
Yeah, not really. Yeah, there's no real way to enforce it. I mean, I guess what you could do is, I suppose the Security Council could convene. Now, it's important to note that UN resolutions are not binding either. The only UN resolutions that are binding are those passed under Chapter 7 of the UN Charter at the Security Council, and there are not many of those resolutions. So really,
Even those
it would,
have enforcement deficiencies, correct?
yeah. So, that might be the only way, or like individual countries could try to enforce it, put sanctions or something. But in
Right.
general, it would be hard to enforce.
Okay. This is from a colleague who is conveying an anti-Israel activist's recent tweet about the ruling. The anti-Israel activist says, a quote, ceasefire is what you demand in an armed conflict. In a genocide, you demand an immediate end to all genocidal acts. And that is exactly what the ICJ ordered with immediate effect. Stop with the Israeli spin on this historic defeat as a win. So I think you alluded to this earlier that that's not what the ICJ demanded, correct?
Yeah, it's
Meaning,
not what they demanded. I mean, I would just throw it back at them that that's their nice spin on it. But the court said Israel must stop its genocidal acts, but Israel's not committing genocidal acts. And just the fact that people, again, it's very important to note, again, I'm not saying it's not awful, it's upsetting. Um, but people are killed in war. Civilians are killed in war. The parties have rules they have to follow, but just because a civilian has been killed doesn't necessarily mean there's been a legal violation. And again, I know it's hard, because no one wants to see people killed. No one wants innocent civilians killed. It's absolutely awful. Um, but it doesn't make it a genocide. And so, that's really the difference.
another question is, can you speak to the concern that Western nations are now having in regard to decisions like this? How even just bringing the case to the ICJ may hamper, other countries' ability to go after non-state actors, terrorist groups.
Yeah, I mean, I think that's a real problem here because especially if they'd ordered the ceasefire, or not even a ceasefire, just is they can't order a ceasefire because Hamas, they can't, or they don't order Hamas to do anything. So it would be a one side. So again, you're not stopping the fighting because Hamas isn't stopping the fight. Um, so um what if they had ordered that, what kind of message would that send? It's basically you have this UN court, supposedly the, main arbiter of international law, basically saying terrorist groups can commit massive atrocities, embed themselves completely in civilian infrastructure, endanger its entire population, and they can do it with impunity. I mean, that would be ridiculous. And that's what South Africa was asking them to do.
Right.
So I'm glad the court at least exercised some sense. Also, would have been Israel also has a right to self-defense under international law.
Right.
So by ordering that, it would have been eliminating the right to self-defense, which would have made no sense also.
You think as much of a show this is, there are certain unspoken red lines that even, the ICJ is understanding here, that their reputation is kind of on the line to some extent.
Yeah, I think so because, I think this court cares about its credibility. And if they had ordered something so ridiculous, they would have gotten a lot of criticism.
Right.
And also their ruling wouldn't have been followed, so it wouldn't
Right.
have boded well for the court.
Okay, another question starts out a bit of a comment because it's alluding to the recent controversy with UNRWA about the 12 who were terrorists on October 7, and UNRWA is UN, ICJ is UN. So I guess the question is, is this complicity of UNRWA, is that also could that also bring down or offer or be a taint on the United Nations because it's all sort of connected. Um,
Yeah, for sure. I mean, I think UNRWA, the higher ups in UNRWA need to be held responsible. I'm not sure they can be under the Genocide Convention, but certainly I think there are other ways in which they can be held responsible. Possibly even under the Genocide Convention. I'd have to look at the rules more closely,
right.
in terms of how UN agencies, if they fall under that, or how that might happen. It may not be through the ICJ, it might be through national courts or other courts. But definitely I think they should be held accountable for what they've done.
Another comment, not under the Genocide Convention, but it seems a ground to request that any claim be adjudicated elsewhere. I guess, yeah, I mean, if you're not going just with the Genocide Convention, it opens up the playing field.
Right.
Okay. Um, yep, hold on, another question. Um, I guess, in terms of the timeline, what should we be bracing ourselves for going forward? I know you had said this is kind of like this is just a long slog here with waiting for a decision. What are the realistic expectations here with them even
Well,
adjudicating?
yeah, so the court hasn't even set a schedule yet for the coming rounds. So presumably Israel is going to make some kind of report in a month. But I don't know if I don't think they have public hearings about that report. I think it's just submitted to the court, as far as I know. And they haven't set a schedule they haven't even really heard anything in the court yet. It was mainly on these what are known as provisional measures. So it could be, many months until they hear anything about it. And really, it's this other case that's coming up. So this other case, the advisory opinion is coming. So the oral arguments are taking place in February, and then there's probably going to be a ruling about that in July. So it's likely we'll hear about the advisory opinion before we hear anything on the genocide case.
Okay. All right, I don't see any other questions. I will be asking again in the chat, but if not, we can wrap up. Do you have any other comments that you'd like to leave our community with before
Yeah, no, I
I wrap?
mean, I think, it's very frustrating. The problem is it's very easy to make these kinds of cases or level these accusations. And it takes a lot of work. It's much harder to refute because it's very easy to say you're committing genocide. And then in order to refute it, you can't answer that in one sentence. You can't just say, no, I'm not. You have to, it takes a
Show up.
lot. And also you have to, it's like you're being asked to prove a negative. Prove to me you don't have a sister, and so that's also what Israel's being asked to do. It's not committing genocide, but it basically
Right.
has to prove a negative.
Right.
So it's very difficult. So again, it's like you're already at a disadvantage because this horrible allegation is made, which has a lot of emotive resonance and propaganda resonance, but then to refute the charge, it requires lots of words, lots of describing complex, issues and facts. And by then you've already lost people, like trying to explain it all. So, that's really what complicates things. And, that's kind of been the issue all along. Like Israel's constantly being accused of these things and forced to respond to them at a disadvantage.
Yeah, absolutely. Before I do a couple of closing remarks for Club Z, I wanted to also highlight the great work that NGO Monitor does. I mean, it's and it goes back a way. I've been an activist for a while, and NGO Monitor, their reports are so in depth and they're so also clearly easy to understand. And considering that it is a confusing morass of the international community's war on Israel with countless NGOs that sound so innocuous. God bless NGO for being out there and issuing, doing what they do. Can you just speak a little bit about what they do and how our community can be more involved and tap into their great work?
Yeah, sure. Thanks for the kind words. So we've been around since over 20 years. And basically what we do, we have two things we kind of do. Number one is we look at non-governmental organizations, NGOs, and their role in the conflict. We look at their funding, because many of these groups that are doing these anti-Israel campaigns are receiving money from governments from the US, Canada, Europe. So we look at what are they getting money for, and then we'll write reports about that, provide them to government officials, because a lot of times they don't even know what they're giving money to. They don't know that they're funding anti-Semitic types of campaigns, or
Yeah,
BDS campaigns. So that's one aspect. And then there's the other aspect where we actually take a close look at what the NGOs are saying, how they're operating at the UN. So, for instance, some of the NGOs we cover were very involved in helping South Africa put their report together, their complaint together to the court. And so we take a look at what they're saying and we debunk the false claims in these reports. So that's sort of the other piece of what we do.
right. And just for those who don't know, the range of NGOs, it could be, like a 6-person entity that's, innocuously titled, Children for Palestine, for Palestinian children. I think there's DCI Palestine. It could be also something as big as Amnesty International, right, or Human Rights
Correct.
Watch, who have such an effect on public discourse, and especially with the recent apartheid accusations. So I recommend
Yes.
anyone go to the NGO's website to understand that apartheid accusation as it's taken apart point by point very methodically. So thank you for that.
Yeah, sure.
Okay, just a couple of announcements from Club Z. For those who missed Jake's opening remarks, February 5 is our adult crash course, 4-session online course focusing on Jewish and Israeli history and how to respond to the lies. Beginning March 4 is our teen crash course, also 4 sessions online. Also connects, besides just teaching how to confront the lies, it connects Jewish teens with other Jewish teens and Zionist teens across the country. And as Jake mentioned, from February 23rd to March 7, we have renowned author, attorney, public diplomacy expert Ron Bar Yoshafat, who's going to be on a national speaking tour. And he set aside time to speak to Club Z's audiences in New York, LA, Bay Area, and North Carolina. We will send out more details on that. Also, the vital and important work that we are doing at Club Z cannot be done without the generous help of our supporters. So please consider joining us to help create the next generation of proud and articulate Jewish activists. I have provided a donate link in the discussion. And then finally, our next webinar is Wednesday, February 7th with Nico Black. He is an ex-IDF humanitarian liaison with the Palestinian Authority. So he's got some very amazing stories to share on that front. He is a conflict researcher with nuanced views and strong connections through his family to B'Tselem and, go figure, The Guardian. So he has a very interesting perspective to provide. And the name of that webinar is Israel Caught Between Humanism and Self-Preservation. So we like to tease these events with provocative titles, but that is really going to be what he's discussing. It's going to be an amazing webinar. And thank you so much for taking the time. I know it's late in Israel. And thank you for all the work you do, along with what NGO does. And so we hope to have you back, and hope you speak to our community maybe in person at some point in the future.
That sounds great. Thanks so much for having me.
Okay, thank you again. Be well.
Okay,
And thank you
bye.
everyone for joining us. Bye-bye.
Bye.